The outlawing of Section 22A, subsection 3 of the Criminal Law Codification and Reform Act, which is commonly referred to as the Patriotic Act or the Patriotic Provisions, represents a significant change story in the quest and fight for the implementation of freedom of expression as obtained in Section 61 of our Constitution. Our challenge in court of these particular provisions were mainly hinged on at least three accounts. Number one, the framing of the provisions were, in our view, ambiguous to the extent that they would have been open to wide interpretation and possible abuse. Secondly, it sought to dictate how and with whom the citizens of Zimbabwe would engage, in particular as it referred to foreign nationals and indeed foreign governments. The other issue we had were what the law sought to do as measures or the punitive measures which we felt were inappropriate and indeed were harsh, that of recusing the right to citizenship, the right to vote, and so forth. So that was the main thrust of our arguments. But even then, we were looking at the case from a journalistic point of view, to then say for journalists whose news sources are far and wide and whose sourcing also depends on the right to associate with the government nationals, including those of international governments. It was going to create an environment that would entrench censorship, as it were, which definitely would not have made journalistic and media freedoms to thrive. So from also that standpoint of media freedoms, we felt compelled to take up the matter within the judiciary. As you know, the function of lawmaking is also vested in the judiciary by them being able to interpret the constitutionality and legality of the country's legal framework. So to that extent, we do welcome the ruling which found our arguments persuasive and which also drew attention to the need of government, the executive arm that is, and the legislature as well, to in future cases try to have watertight legislation that aligns with the thinking of the supreme law, the rights that are guaranteed within our constitution. So yes, we acknowledge, we welcome, and do celebrate the step, but we do so fully cognizant that this is just but an incremental step, significant as it is. We still have wide-ranging issues that pertain to the media law and policy, that pertains to the broader free expression, market of ideas area, to the broader right of assembly, of association, of engagement, and broadly speaking of our democracy as a whole. So yes, this is a step towards the right direction, but it only but re-galvanizes, re-energize, and revitalize our quest for freedom. It really sets all right at the table at our doorstep in terms of our engagement with government and in terms, indeed, of our pursuit for a free, just society. So it is noble that we have this judgment, yet it's not yet Uhuru.